Well, one of the big issues for farm and ranch families who have a family member interested in continuing the family business is how to properly transfer things to the next generation. Roger McEowen with the Washburn University School of Law joins us now with the latest insight in today's Rural Money segment. Roger, as always, thanks for taking the time to chat with us today. So what type of tax hit is there to retiring owners compared to maybe a sole proprietor whenever there's a farming operation in play?
Right. Good to be with you, Janet. There's a big difference, and with a sole proprietor, when they retire and the assets are sold, those tax consequences can be pretty harsh. Grain and livestock and inventory and your depreciable property, other than your farm buildings, are subject to ordinary income tax treatment on sale. So that could be at a high rate. It just is tied to what the sole proprietor's individual rate will be. Plus, there'd be depreciation recapture. But if you've got a corporation and you sell the corporate stock by the retiring owner to get them out of the business that way, that gets taxed at capital gain rates, and those are often lower than the ordinary income tax rates.
So what is the advantage of a corporate stock redemption that's in play?
Well, the corporate stock redemption allows you to get that individual, that senior member, out of the family corporation by removing post-tax wealth that is built up inside the corporation at a 21% rate. And that's the same outcome for future wealth that's built up if the payout occurs by virtue of installment reporting. So you get a favorable tax break.
Are there any other advantages? Or rather disadvantages even too?
Yeah, there could be. There would be no increase in stock basis in the hands of the acquiring next generation. And that's even the case even though the seller, the senior member of the family, could have a large gain to report on the transaction.
Now, I understand that a complete redemption is also required for the transaction to be eligible for installment reporting. Expand on that if you would.
Yeah, that's right. You have to completely buy out that senior member, and that's necessary for a number of things, including installment reporting. And so they've got to deal with a 10-year rule when there's a complete redemption, and that means the former senior shareholder can't be a consultant, they can't be an employee, they can't be a director during that 10-year period after that complete redemption. So there's no salaries or director fees for 10 years, but you can continue to employ the spouse and provide fringes that way. And there's possible ways to do some leases, but there's a 10-year restriction on just about all the involvement post-redemption.
Roger, can prior family transfers ever cause a hiccup in this process?
Yeah, they can cause a snag because there's what's known as an anti-abuse rule, and that says that capital gain treatment is not available if there's been family transfers of the stock within 10 years before the redemption. So you got to watch what are known family attribution rules, and this really means all of this has to be planned well in advance and a lot of thought given to it. So people need to be talking to their tax practitioners well in advance of trying to transition to the next generation.
All right. Well, Roger, as always, thank you very much for your insight today. Roger McEowen, he's with the Washburn University School of Law, joining us on the phone today from Topeka.